GNLU alumni, I can say. Professor Sharma, Mosmi Sharma, and she made recalled me that she studied in GNLU in 2015 batch. So I thank to her as well that she remembered me, in fact, since she is a GNLU alumni. Uh, Indeed, it's my privilege on first note. Uh, I feel privileged and honored. I'm delivering a lecture, a sort of discussion, in fact, because the subject is research methodology. And I can see every individual who are participating as a student, as a faculty, colleagues, one or the other way, they must have experience about research. So my major focus would be on discussion point rather than to deliver a lecture. Okay, I prepared a few points for the discussion today, and those you must have experienced also. But I will take you on a different thinking process, and which is very essential because we are habitual to think on a one side, which I experienced for almost around 10 years, 1 decade. And then I started thinking on the other way around, where my scope of thinking on a particular subject in which I am interested upon has completely changed. And that's why I prefer, instead of to tell you about the theory in the research methodology, which you easily available in the books, you can read out also at the time appropriate when you get a time. But the thinking process, which I want to discuss today, which is very essential for our research work. Some of the points which I will share today with you, which I experienced, and some of the issues where I have gathered it from the different authors on the different jurisdictions. When I say different jurisdictions authors, it means authors from overseas as well. I am sharing you first a slide, my screen with you all. If it's visible, I request you just give me a signal that it's visible so I can go ahead accordingly. Uh, is it so? Can you see this?
Yes.
Okay.
Yes, yes, yes.
Okay. Okay. So my today's topic, I was very careful when I have given the topic. Research methods. It's not research methodology. There is a difference when we use word research methodology. I give an example of it. And if we have a different understanding, you just let me know by a chat. Research methodology, for example, is that if I ask the questions in an empirical survey by asking questions or taking an interview. So this is, I'm using a methodology to collect a data. While research methods are of basically of two kinds, which we know theoretically, is that it's a doctrinal research and a non-doctrinal research. So the research methods is different than what we used to write generally and feel it's a synonym. That's research methodology. That's why I have written it's about research methods. It means that either I may talk, which may help us to do or conduct a research for empirical, or you can say a non-doctrinal or a doctrinal. That is by sitting in an AC library, by sitting in an AC room, what do we research and analyze it? That is called doctrinal. I generally remember in that way. So it would be easy for us to distinguish the doctrinal and non-doctrinal. But let me give you one point, which nowadays the UGC also much more emphasis. especially for those students and the professors who are writing research papers and the research projects. Nowadays, the publication journals as well are more emphasis on empirical surveys and empirical research rather than simply analyze the cases, analyze the situation and the provisions which already in place. So our try would be that instead of we focus on doctrinal, we should more focus on the empirical survey, that's called a field survey, or you can say non-doctrinal research. That's what UGC nowadays is more emphasis upon. If I go with the first and practical aspect on the first slide, think on the following three questions which I have made it out. One is, why do we have to discuss about research? This is one. Second question is that is a legal research is different than the research conducted or conducting in the other disciplines. This is second. And third is, am I bothered about the kinds of research? Because generally the experience is with everyone, including myself, was when I received any comment or when I received any instruction from my teacher, I generally more, inclined towards about the doctrinal research instead of to go completely on non-doctrinal research. So the first point here is that why do we discuss about research? Research we have to discuss for the purpose to show your creativity as a researcher, as a student, as a professor, you to show your contribution, and ultimately your contribution would be towards the development of the society, not necessarily always to the development of the government, but development of the society. And ultimately, it would benefit to us. We will go with the exercise also that
Yes.
how it would be. So I, as a student of the undergraduates, since I have to prepare my research projects in every subject, I have to undergo with the research. And I'm very comfortable and very easy option available for me to do a doctrinal research. How doctrinal research would be created more effective, that I also will discuss on the later stage. But on a first option, if it is very easy for me, I generally opt the doctrinal research. And I generally ask to my teacher or a supervisor that which topic I supposed to do research. And that's a wrong attitude. Always keep in mind that we are not going to identify any problem. We are not going to select any problem. We are going to have to identify the problem. Problem which I can see by reading a column in a newspaper or by reading a news in the newspaper or watching a TV or a television, the problem which I can identify and I can think of might not necessarily that my supervisor has thought of, not necessarily that my teacher and undergraduates has been thought of. So it's always better that do not all the time, right, confine your thinking process towards the specific topic or a specific tool, or you can say the specific research methods. That's the doctrinal one. So I do, discuss about research because of my own contribution towards the society. People will recognize me only if I give a good research piece of paper. And then only, and then by that way, I'm contributing to the society, myself also getting benefited out of that publications. But keep in mind, and that is a bit technical also, when we are writing, when we are discussing, when we are thinking about research, the one issue that is the intellectual rights that comes in between. I will discuss it on later stage, that how this plagiarism and this IPR issues comes when we are thinking something that's already been thought by someone. I repeat, and it is quite happening. What you are thinking, it's already been thought, already been written by someone else, right? So the issue of copyright would come into the place. So I will go that how we should over look of all these things, that how technically that we're supposed to be much sound when we are describing our own ideas before a supervisor or before a teacher or before a professor, right? So, and obviously I benefits about, and we are discussing about researchers because at the end of the day, my submission on the paper, I'm going to be accessed and evaluated. So obviously for that purpose, we are discussing about research. So 3 points on the first question I said. First, we are going to discuss about research. It's because of my own contribution as a student. Second, we are discussing it's about the research. It's because it's ultimately helping to the society. There's a second, and people, it's going to remember you forever if you're writing a single piece of your research paper and publish in a very good journal. This is a second benefit. And for that reason, we are discussing about research. And the third and ultimate is that anyway, my research project or a research paper, I'm going to submit it to my teacher. If it is PhD thesis, I'm going to submit to my supervisor at the end of the day, and then the university, I'm gaining a degree. So you may find that the benefits are enormous. And for that, we are discussing about research. This is one. Second question, which you can see it's about, is legal research different? Nowadays, even UGC and Bar Council of India as well are more emphasis on multidisciplinary research, or you can say that interdisciplinary research. And it says that as a law faculty, you can very well associate with the other than law faculties in terms of research. If we see the research papers written by our top universities in the world, Harvard, you can say Yale, you may find 3 to 4 professors together. They are writing a paper. And then they are publishing in such a way that can help to ultimately to the government, their own government. Even at the time when you are applying for the fellowship, for example, Sastri Indo-Canadian Fellowship, if you're applying, they want a good collaboration with the faculty from the Institute of Canada. And they want, it means that the SICKI, that's the Sastri Indo-Canadian, which I'm talking about, it's a government institution, sponsored institution of India and the government of Canada. They want a collaborative research through an institution, 2 institutions collaborate, 2 professors collaborate. So you as a teacher, at the same time, they also inspire students, collaborative students. So you may find any student from NEF college, he may collaborate in research through an application under the SICKI to the another student of the institution situated in Canada. So there are members, it means that Government of India and the top universities across the world, they are emphasis more on interdisciplinary research. And now top of that, multidisciplinary research. So you may find that it's not only law, but there are many other disciplines. So now the point is that do I deliberately, and remember this, do I deliberately associate my legal research with the other disciplines? Answer is no. Why? Because my thinking process is different. No subject, irrespective of the subject, you may take it on the different discipline or from the law or topic. You may take it either from the law or from other discipline, right? They are not separated. They all are integrated itself. Now it's our role that we have to segregate it. So it means that, for example, I'm giving you a title. Can you see that that title, can I, based on that title, can I research without looking into the other discipline? Now I'm reading the title, I'm just telling you a title, an administration of criminal justice through reformative jurisprudence in India, colon, myth or reality. I repeat the title because I want you to think on. I repeat the title, and your job is to is to think that, can I research exclusively in the legal area only, or I supposed to take the help of other disciplines as well? I read the title once again. The title is Administration of Criminal Justice through Reformative Jurisprudence in India, Myth or Reality. Now, first observation maybe is that I cannot read the criminal justice system without looking the sociological aspect. I cannot look into the judiciary without observing the psychology of the people. I cannot read my own or analysis my own law or my own topic without looking into the Constitution of India. So it means what? It means that the subject which I said, it's already interdisciplinary in nature. Now it's my job whether I want to turn that subject into the economy, psychology, sociology, law, or exclusively, I can that depends on the researcher's interest, and it has to be carved out accordingly. And that's why, so the answer of the second question, which you can see, is legal research different than the other disciplines where the research conducting? The answer is no. So far as the research is concerned, it's not at all different, right? It means what is the difference that we will see on the later slides. Say question number 3 that you can see on the slide is that, am I bothered about kinds of research? And kinds of research are two kinds. One is doctrinal and another is non-doctrinal. Now it depends on our thought process. It depends on our title on which we want to do research. That title will decide that whether I should require to follow the doctrinal survey, or I supposed to analyze it exclusively on the secondary data available, that is the doctrinal research, or I supposed to be in some point of time a mixture of both. That also happens, and nowadays it's always benefiting. I give you an example of it, that how we can, based on the title or a first draft of the title or a theme, we can decide that whether I should go for a doctrinal, it's more benefited, or I should go for a non-doctrinal, it's more benefited, or I supposed to rely first on the primary data through a survey. Half of the research is through a survey, and the remaining I can manage it with the existing secondary documents. It means the doctrinal research. We should have an exercise also, if time permits. I will give you some topics. Your role would be to see that in this title, whether it's more benefit to the society is a doctrinal or a non-doctrinal. But we will see once I finish a few basic introductory part of the thinking process. If I go with the second slide, and that speaks about 1 minute. It's there are three things. There are four things which I have mentioned. One is we do research for different purpose and object. Am I right? For example, I do research, and I started. In fact, I give my example on it. I started research on a first year of my LLB, and that's not at all. The research was based on the guidelines given by my senior advocate, and that was a one case, and that case was with reference to the defamation. And I was in the first year LLB, so I could not stand before the court of law, but all the role which I played in that case, that was I prepared a brief to see the procedure. I read few cases from the ready references that can be put forth by my senior before the court of law. I read the entire file, that the documents which were exhibited in my favor and against as well. So ultimately, I given a 3-page note to my senior. So now what I did, do I consider today that what I did on those days can be considered as a research first? And the object for that research to prepare a notes for my senior, and then read the few cases, then the facts, then the documents which exhibited by the courts, right? That I did research. My object and the purpose was different, right? If I go with the academic research, it's different. Right? If I'm writing a newspaper column, my object and the purpose for the research is different, right? If I'm, as a student, if I'm writing a project, research project, on a specific subject, right, my purpose is different. My object is different. So it means that if your purpose and object is different, your presentation in writing would also be different. I give an example. In a research paper, in a published research paper, apart from the abstract, we never find that the object and the purpose, that specific category is mentioned in the research paper. But that is not the case when you are writing a dissertation. That is not the case when we are writing a PhD thesis. That is not the case when we are giving an opinion paper to your senior counsel or to a judge. This is not when we are reading a newspaper column. So it means that it depends on the purpose and the object of the research. What would be the proper structure of your writing? And structure of the writing only decides that whether, decides by whom? Your structure of writing decides that whether this piece of research is readable or not. Reader always look into the abstract, for example, when he wants to read a detailed research paper, right? At the same time, if someone is reading your dissertation or your research project of 20 marks, which you generally submits to your teacher, what teacher will see into it? They will see first that the structure. Now, the structure here, when you are submitting a research paper, is different. What structure it means? That first observation, if I give my example, I generally go with the chronology. Whether your previous paragraph is in context or in chronology of the following paragraph or not. And if it's not matching, it means that something it's missing in between, right? So your object, your purpose decides the output. You can say so. You're writing for a dissertation, structure would be different. You're writing, it means that you have to write aim, objective, purpose, etc., etc. Hypothesis, research questions, and then chapterizations. But if you're writing something for your for publishing a paper, you're writing simply an abstract. But that abstract, how to write an abstract, not on theory, but in practice, if time permits, I will let you know. In an abstract, you have to show everything. Everything here, it means that the researcher's main aim to write this paper, researchers' main hypothesis, researchers how answer those hypotheses or questions, that also would be a part of your abstract. So abstract is nothing but your entire research paper's outline. And every sentence has a meaning, because we have to write only in 400 words or in maximum 500 words your abstract. An abstract has to disclose everything, right? So that's a skill that we need to practice, and then according to it, we can develop as well. So the first point which I have written here is that we do research for different purpose and the object. My answer is yes, your answer may be no, but yes, different purpose and the objects are different. And that purpose and the object decides the output of your research. Do we read, second point is that, do we read different documents differently? Just think on. I give an example of it, a pure practical aspect. I am reading a law commission report, for example. Now my reading, because I'm reading for a specific purpose. And for that specific purpose, my first focus would be on index in the law commission report. And into it, I have to see that how this law commission report has been structurized and which part or which chapter is important for me. So I'm reading law commission report differently. Then I'm reading a research article. Then I'm reading for the journal publication. Then I'm dissertation, right? So it's different. So we are reading different piece of research differently. If I'm reading a case, decided case law, a very landmark judgment, for example, I'm giving an example why I'm using landmark. The approach of the reader on a landmark judgment reading must be different than other than landmark judgment. Now, if I experience, for example, 2018 was a year where you may find a series of judgment of the Supreme Court passed and landmark judgment, right? That is, for say, women's right, Sabrimala issue, then Aadhaar issue, all judgments which come out, Sahabano's issue, all judgment which came out in 2018. Now, reading this 400-page judgment, that document, right, is different, and because you have to analyze it further. Then you are reading a research paper, because research paper, it sometimes becomes a literature review for you, but analysis of the case is not always, or in maximum time, it's not analyzing the literature of review, but it's analyzing the question of laws, right? When we are reading the judgment, I give an example on my experience. You are reading a judgment decided by a trial court. You are reading a judgment decided by a high court, same issue, same case, and you are reading a judgment decided by the Supreme Court. Your observation and the court's output would be different. For example, if I say that you are reading a judgment decided by a trial court, you are more acquainted with the question of facts, right? If you are reading more on the high court judgment, right, you are more gaining information about how the question of facts have been channelized and interpreted with the brackets of the question of laws. So it means that question of law legislations interpreted based on the circumstances and the witnesses and the facts decided by the trial court. So it means that applicability of the laws or the provisions over the facts. That's the observation of the judgment passed by a high court. But when we are reading the judgment passed by the Supreme Court, the observation would be same judgment, but same issue, same party, same case. But when you are reading the same case output at the level of Supreme Court, your focus is only analyzing the law. You are never been concentrate, right? You have never been allowed to concentrate. Why I say is allowed to concentrate? Because nowhere in the judgment passed by the Supreme Court, you may find that the analysis of the facts. You may find the facts, but not analysis of the fact, because that's not a job of the Supreme Court. Supreme Court job is only analyze the laws, right? My here concern is that when we are reading different documents, we are reading documents differently, right? And that we have to accept that. When we are doing research, right, when we are reviewing the literature for our own research, we keep in mind that why I'm reading this document, for what purpose, and how I'm going to be benefited by this, right? So second question, yeah, it's differently. We are reading different documents differently. Now, the third point which I had taken it's from the one research paper. Um, and that is that, am I good reader? It says that, am I good reader? How do you decide? You means, how do the supervisor decides that, am I a good reader? Now, general philosophy, don't accept it. I'm just giving you and draw your attention on that side. General philosophy is that if you are good, in reading, good, it means what? You are very fast in reading. The capacity, intellectual capacity generally increases. It means that you are highly intellectual. Sometime with me it happened. I don't know whether it was happening with you or not. But it happened with me that when I start reading very fast, I finished it very fast, but I could not gather which I expected at the time when I started reading on it. So it depends on the researcher. Kindly don't focus on that. Those who are a very fast reader may accumulate very fast. I don't know, but one of the research papers has analyzed this and says that if you are a very fast reader, you are a good reader, and you can analyze very fast. That I kept on you to decide on that. The fourth point, we generally find it that research paper or a dissertation, any piece of paper of research, either you may find it's an analytical, it may be a critical, it may be a descriptive, or simply an investigating something, and then you can say that it's an paper. It depends, however. Now I have to give a proper idea that what do you mean by analytical, what do you mean by critical in the legal research, what do you mean by descriptive, and how do you say that this is an investigative in research? I will let you know on the next slides. But let's go with the different papers. Okay, now there are different kinds, or you can say that research. There are 5 points which you can see on the slide. Doing research as a student or as a professor, generally called as an academic research. Why I highlighted this? Because academic research is different than the other kinds of research. For example, if you compare the first academic research with the second point, fact finding and application, doing research as an advocate, their research is not academic research, and it's different. He has to research based on the facts he collects from their clients, and they analyzing the facts, and then they are reading it with the law and trying to push it at that how this laws interpreting and fit in with the given facts. So there, as an advocate, doing research is different. Doing research as a court officer, as a judge, right? It's completely different because if you are preparing a case as a plaintiff or a petitioner, though you are thinking much on the defendant side, but you cannot think the way that thinking by the court officer, because he has to read not only because you have said something through an affidavit into the court, but he has to read and analyze it based on the witnesses' statements and other documents which are submitted by the parties and exhibited it. So his thinking process, his analysis on the same facts which otherwise counsel reads and submits it is different. That we have to understand. Um, because why I say this, because when you are reviewing the literature, any case laws, generally we are habitual, and I more emphasis, including myself, we are habitual to read Supreme Court cases only. We hardly bothered about reading the trial court cases. We hardly see about the high court cases, right? We generally says that it's a Supreme Court case, and then condition precedent 141 of the article Constitution of India generally prefers, and then we read on. But it's always better and benefited to all of us as an academic researcher as well. When we are analyzing the Supreme Court case, it's better that we should go with the file which submitted, documents which are submitted in the trial court and then the High Court and then the Supreme Court. Majority cases, you may find if it is of your own state's case, then in majority of the cases, you may find the material either with the lawyer who represented the High Court, all the material which presented into the trial court. So it's not that much difficult task to read the entire file which prepared and submitted by the trial court to the High Court at the time of filing an appeal. So research court officers' ideology, thinking process is different. Legal advisor, right? Legal advisors analyzing the facts and indicates the existing position of the law, right? And that's the very important. Last point, it's research as an policy contribution and the draft of legislation. Now, this is one of the subjects also which Bar Council of India has suggested, and we have a subject in the last year of the 5 years integrated course. It's about drafting and pleading and XYZ. Now, at that point of time, this point is very important, drafting a legislation. Your thinking process would be different. Your reviewed literature would be different. Why I say is this, because drafter of legislations, the base is, if I say that how the law commission members are collecting information, right? They are advertising it by saying to the public, saying that this law is going to be enacted. Any people of the country wants to give their suggestions. They are inviting suggestions from all of us. Tell me how many of us that we have given suggestion whenever the Law Commission of India announces that they're going to recommend through a Law Commission report, right, to the government to enact the law. There, our contribution, I think we can show. So last point is very essential. Policy contributors and drafter of legislation, and their role, where we as an academician, we as a student can play a role into it. Now, just think about the following. How do you read the entire document called Law Commission report? Has entire document, I'm not saying only index. Just think about yourself as a student, right? Have you read the entire document called Law Commission report? This is one. Why I say this and why it is important as a researcher is because there are many issues that you may come out with. For example, if you simply observe any area in which you are interested, you observe the Law Commission reports on that area, and only observe and read the index, nothing else. Don't go with the all 300, 400 pages. I'm not recommending that, but only go with the index. It's how structurized. That structure is based on mostly empirical survey, and then the cases analyzed or produced, or you can say passed by the Supreme Court of India, right? These are the two major, reliance on which the Law Commission reports generally prepared by the retired judges and the chairman of the Law Commission of India and the members. Second point is, have you read the research themes publishing by Department of Justice? I have. I will show you that. Have you ever prepared a brief notes for your senior counsel during your internship? I have a special question to the students. At the time when you're doing an internship and your counsel says that you have to, prepare a brief notes on the case on which we have a hearing tomorrow, for interim relief or sake of only to, ask for adjournments also. Even for adjournments also nowadays, the courts here are very strict. They generally not, trial courts are not giving much adjournment nowadays. It's because of pressure, and they are asking the arguments on that. So for that, if you have briefed the notes, you just think on that. Have you ever prepared question of for chief and cross examination for your witnesses? Is a skill, and that's also a part of research, right? Drafted an abstract for the research paper. If you have drafted, what you have included, every sentence in an abstract is important. As I said, your 10-sentence abstract, right, has to disclose your aim of your research paper, objective of your research paper, hypothesis, and then how you are going to resolve that hypothesis would also be a part of your abstract. Otherwise, your abstract is going to be rejected, right? I'm talking about the publishers who are generally under the Scopus or generally under the publications from the overseas, publication house from the overseas. So that's very important. And then Supreme Court hearing, prepared arguments for the Supreme Court hearing. Now, if I answer of this, and if we go with the practical aspect of this, it's let's go with this because it's very easy to say, but it's very difficult, when it comes to the practice. Teaching what, why, when, and teaching what, it means teaching what about research methodology or methods, teaching why about methodology, teaching when research methods would be utilized. Is enough for a teacher teaching the research methods? I observe it's no. We should not go with why, when, and what. In fact, we should go with the practical aspects like this. Now, on this slide, you can see that what I've written, themes which Department of Justice has published on the official government website. Now, what I've written on the first point underlining is a theme. In both the sides, you may find different themes. And the first point and the second points, they have given a title. That is the topic in which they want that the student or a researcher or a professor has to conduct a research. Now, my question is on this. The first point, do you feel that the first point is empirical survey or a doctrinal you can manage the things? Study on lower judiciary, how to ensure the expedites the disposal of the cases. If I go with the methods, research methods, title suggests that it is an empirical survey. It's not a doctrinal one. Can you use the doctrinal methodology, right, and finish your research? So far as the first point is concerned, the first topic which has been suggested. So what I mean to say in practice, by reading a title, we should come to know that whether the researcher intent is to conduct a survey, that is the empirical survey, he wants the empirical non-doctrinal research, or he wants a doctrinal research. If I turn, see, this is also a skill. The first point, if I turn other way around, I can manage with the doctrinal as well. Now, the topic which you can read, study on lower judiciary, how to ensure expedites the disposal of the cases is a non-doctrinal, it's an empirical, because you have to conduct a survey, because you are going to study, and that is for the lower judiciary, how they expedite the disposal of the cases, right? How they expedite the disposal of the cases. So I have to ask the question to the judges. I have to ask the questions to the government pleaders. I have to ask the questions to the defense lawyers, and then clerks, court clerks, and everyone. So it means that I cannot manage with the title with the doctrinal research. But if I change a one word, I can very well manage with the doctrinal survey as well. For example, I use the word contribution, if I'm just adding a word contribution of the lower judiciary, right? How expedite the disposal of the cases. It means that I will take up the cases last decade, and I will just pass the judgment by the lower court. That is, for example, second judicial magistrate first class court, right? How much cases in 10 years time period it has been disposed of. So that it means I'm converting the non-doctrinal research into the doctrinal research, right? So it's very, very easy for us, to convert it from non-doctrinal to doctrinal. The essence here is that we should know by reading the title that whether it's fit for the doctrinal one or a non-doctrinal one. If I go with the reforms in procedural law, the point, this is the topic which Department of Justice more emphasis upon. That's the plea bargaining. Review of impact of schemes of plea bargaining in criminal justice system, including jail reforms and its advantages and disadvantages. I prefer that it's a doctrinal one rather than non-doctrinal, because review of the impact, for the purpose of review of the impact of the scheme of plea bargaining, I have to see the decided cases by chief judicial magistrate in last 5 years or 10 years, and then I can see that what's the contribution of that criminal, of the plea bargaining into the criminal justice system. So on your left-hand side, reducing the pendency study on the lower court judiciary. It's an example of the imperial laws. You may find it review of the impact of, right? It's a doctrinal one. So that decides, in fact, practically, that whether the researcher wants to do a research or to conduct a research in the doctrinal or a non-doctrinal arena. This is the last report submitted by the members of the Law Commission. That is 277th report. After that, there is no report yet submitted by the Law Commission to the Government of India. That is the Ministry of Law and Justice. And that's the wrongful prosecution. Now, why I have mentioned here, if you see the second point into it, next point to the wrongful prosecution, that is the name of the name of the report. But if you see the sequence, it's what they have mentioned into that. It's introduction. So structure is very important. That's what I said. And according to the structure, your reading process has to be there. Then you will go chronologically thinking process, and then you can, get benefit from that document, right, for your own personal research. See the introduction, what's the sequence, then and reference. Second is data analysis. Third chapter is international perspective. Fourth chapter is current scenario overview, and inadequacies exist in India so far as the wrongful prosecution is concerned, because nowadays everyone goes to the court of law, and ultimately after 10 years it finds that the prosecution is wrong, right? And so he has to be punished because he has wasted 10 years, how much time of the courts that he has been vested upon. That's the main object of it, of the wrongful prosecutions. Standard of miscarriage of justice, conclusion and recommendation. This is a structure which has been prepared. Now, analysis, international perspective, current scenario, all are doctrinal. So by reading the structure also, we should know that there is no empirical survey conducted by the Law Commission, but it's only based on the doctrinal research. They have come up with the report which submits by the members of the Law Commission of India. Last point for today's discussion is about, I'm just giving you a structure. Those students, undergrad students, you remember this. In majority of the cases, your structure would be accordingly of your research project when you are submitting a subject to your professors. First is introduction, and I'm very categorically writing context and general background. Obviously, that context and general background to learn, that takes 2 lectures of 2 hours. Every sentence, right, has to read properly, has to write properly, because because introduction is a mirror of your research. That's why context and the general background is important. I will not tell you, if time permits in future, I will not tell you simply that this is an introduction. I will make you write a first sentence into the introduction. That's the important point, right? Then literature review. This is the second. Now, just to give you an highlight on why literature reviews comes in a very second point. Idea which you have in mind to conduct a research that has been derived from the literature which you have reviewed, that you have to show in the beginning, that which kind of literature which were exists, that it's you read it out, and then it forced you as a researcher to do research on that, right? That's why the review of literature comes to next, a very second point, and this is a proper structure. Third is a statement of research problem. It's not simply a research problem, but it says that why you as a researcher considers that this is a problem, right, which exists and it needs to resolve that. That's why the statement of problem. Then the objective. I have not written objectives. We should have a minimal objective, right? It may be two, maybe three, but very to the point. Don't make paragraphs and paragraphs by saying, or pages and pages, 2 3 pages, by writing it's an objective. Objective would be very specific. Your aim would be very specific. Based on your aim, your objectives. I give an example practically. Your aim must be resolve the dispute, and your objective, it means that by utilizing which tools you are reaching to your aim to resolve the dispute. And this is the difference between the aim and the objective. And objective, that's why I say is categorically, it would be to the point. 2 points objective, it suffice. Don't go beyond. Otherwise, time will come that you will be confused at the time when you collect the data, and you easily get available on the internet, and then the books and the research articles, right? So objective, then hypothesis, or you can say that based on hypothesis questions, your question in your mind, it's your hypothesis, right? So we will go with the, I don't think so we have a time. It's next time when it permits, I will discuss in detail. Then sampling, data collection, data analysis, discussion, conclusion, and suggestions and references. So this is an ideal structure. For your left-hand side, it's for non-doctrinal. Now on right-hand side, it's doctrinal analysis first, and then structure would be according to what you can see on the left-hand side. So assembly relevant facts in a doctrinal research, identify the legal issues, issues on facts and issues of law, right? Third, implement of law on the analyzed facts. That is the analysis of the issue with a view to searching for the law. Fourth, reading background material, that is the history and all. Fifth, it's locating primary material, that is the legislation, delegated legislations, case laws, etc., etc. And then synthesis the issue in context, and then come with the tentative conclusion. Now, this is a mind process. On right-hand side, doctrinal analysis, it's a thinking process. After fulfilling this thinking process, your structure of your report would be according to the left-hand side, what I said in the note, right? So that's the definition. You are conducting a doctrinal survey, and on the other way, when non-doctrinal survey, right? Last, I don't think we have a time now. So exercise for which you can write it down. This is a news one, and this is a news number 2. And from where I've taken, it's from Economic Times and India Times. Now, what I say is that by the reading this background, you have to prepare first a theme of your research, and then a title. First a theme, and then title, because theme is broader, and based on that, the title, right? So with this remark, I end my presentation for today. It was marathon, I know, because 5 for every slide, I have to examples which you're supposed to do, and then your thinking process you have to share with me. So I correct which is difficult. In research, there is nothing is incorrect. Let me clarify. Right? It might be correct or it might be otherwise. Otherwise, it means that goes and reading and observes in a different context. Right? So with this remark, I conclude my today's session here. If any question.